There's some intriguing new reporting from the Washington Post as a new indictment against Donald Trump could come any day, one dealing with the events surrounding January 6th. The Post reports, quote, Mark Meadows, who was serving as Trump's chief of staff at the time, wrote to a White House lawyer that his son, Atlanta area attorney Blake Meadows, had been probing possible fraud and had found only a handful of possible votes cast in dead voters' names, far short of what Trump was alleging. The lawyer teasingly responded that perhaps Meadows' son could locate the thousands of votes Trump would need to win the election. CNN legal analyst Elliot Williams is with us now. And Elliot, why would Mark Meadows, involved in a joking conversation about the lack of widespread voter fraud before January 6th, why would that be important?
So humor is itself knowledge. He could not be joking about the fact that he thought that these claims were baseless if he didn't believe they were actually baseless. And so it certainly could be relevant evidence of, number one, the president's knowledge that he lost the election, but also, more importantly, number two.
All right, people, Jack here. So this is happening right now. On January 3rd, House Democrats exploited a convergence of crises: Judge Sullivan's injunction, Newsom's rebellion, and leaked war crimes documents to advance H.R. 353 with 8 articles of impeachment. The 237 to 140 vote cleared the path for full floor debate on charges that now included unconstitutional war crimes. What made this procedural vote truly historic and devastating for Trump was the bipartisan nature of the defection. 10 Republicans officially crossed party lines to vote with Democrats to advance the impeachment process, while an additional 13 broke with Speaker Mike Johnson on procedural matters, signaling that the Republican coalition was shattering in real time.
The knowledge of people around him, like Mark Meadows, as to whether what they thought as of the president's claims.
It gets to the issue of intent, which we've been hearing about so much the last few weeks, where the special counsel has been focused, yes?
Yeah, absolutely. Now, the tricky thing, John, is that humor, I think, as you know well, out of context can be very hard to convey to other people. And particularly when you're dealing with text messages, the prosecutors are going to have to establish for a jury what, number one, Meadows meant in the text message, and number two, what the person who received it understood it to be. And that's a harder burden than you think, because think about, social media posts or texts of our own or anybody else's from years ago. Out of context, they sort of don't really make a lot of sense. And you're going to have to convince a jury that this information can help establish proof of a charge beyond a reasonable doubt, and that can be tough.
So there was another line inside the Washington Post reporting that sort of had blinking red sirens around it. I want to read that for you here, Elliot. People in Trump's orbit have grown increasingly concerned about what they see as Meadows' retreat from the public scene as a prominent defender of the former president. He has reduced his public appearances, particularly on television, where he was once a frequent guest. He has not posted on Twitter in 5 months. Why does Mark Meadows make the Trump team nervous?
The numbers told a story of a president losing his grip on his own party, of lawmakers who had supported Trump through 2 previous impeachments, finally concluding that the evidence had become too damning, too documented, too undeniable to continue their defense. Trump watched this unfold from his Mar-a-Lago bunker, reportedly in a state of barely controlled rage, sweating through his suit as he furiously typed out Truth Social posts, screaming about impeachment hoaxes and deep state conspiracies, unaware or unwilling to acknowledge that this time the accusations were built not on political disagreements, but on documented war crimes and constitutional violations. The leaked memos showing 115 extrajudicial boat killings now sat in the congressional record.
Well, the plot thickens. Now, certainly, Mark Meadows ought to make the Trump team nervous because he's valuable potentially as a witness. In general, when running an investigation, John, there are 2 types of witnesses. One, people who heard or saw things firsthand, spoken out of the mouth of the target of the investigation, or 2, people who saw things secondhand. Mark Meadows falls in that first bucket. He would have been, number 1, privy to firsthand conversations with the president, but number 2, have overheard countless conversations that the president had with other people or views the president had expressed. Mark Meadows could potentially be a very valuable witness. Now, I wouldn't advise reading too closely into whether somebody chooses a tweet or not, or whether he goes on Jimmy Kimmel Live or not. But the simple fact remains, Mark Meadows could be an incredibly consequential witness when his boss is being investigated for any number of federal offenses.
For Mark Meadows, for his attorneys to let him go in and talk extensively to investigators, if in fact he did, would they have to get him some kind of immunity and or potentially, and I don't want to get too far out ahead here, but some kind of plea agreement if potentially Mark Meadows had any legal exposure?
Their details so gruesome and specific that even the most loyal Trump defenders struggled to find words of defense. The civilian deaths in Caracas were documented in operational reports that described in chilling detail the execution of survivors floating helplessly in the water after their vessels had been destroyed. Judge Sullivan's ruling that the strikes were unconstitutional was now a matter of legal record. A federal judge declaring that the president had violated Article 1 of the Constitution and the War Powers Resolution by launching military operations without congressional authorization. The impeachment was built on evidence this time, not politics, and that fundamental difference was what had finally cracked the Republican wall of loyalty that had protected Trump through every previous scandal.
We are following several breaking news stories at this hour, including what could only be described as a bombshell from ABC News. The network is reporting that former White House Chief of Staff Mark Meadows has been granted immunity and has already testified to Special Counsel Jack Smith. Scripps News has not independently verified that story, and we'll have much more on that coming up. We have live team coverage of several breaking news stories at this hour. Avajoy Burnett is following the latest on the Georgia election interference case, where there was another guilty plea today. Nathaniel Reed is on Capitol Hill with the latest on the speaker's race that is changing almost by the minute. And we're going to be talking to Brad Howard about all of this, who is an elections expert on all of this in just a moment. But first, and now there are four, a fourth defendant and third lawyer of former President Donald Trump pleading guilty in the Georgia election interference case. Jenna Ellis cutting a deal with prosecutors today. She is the ex-Trump attorney who admits she drafted a letter intended for top Georgia officials saying Georgia's election results were false.
The scene at Mar-a-Lago as the vote results came in was reportedly chaotic and disturbing, with Trump appearing on Fox News looking haunted, visibly sweating through his makeup, bags under his eyes that no amount of television lighting could conceal, and a voice cracking with desperation that betrayed the confident strongman persona he had cultivated for decades. This was not the Trump who had dominated Republican politics since 2015, the man who could command loyalty with a glare and intimidate opponents with a tweet. This was a man watching his presidency collapse in real time, experiencing what witnesses described as a psychological breakdown as the reality of his situation finally penetrated his consciousness.
Fulton County DA Fonnie Willis charging Donald Trump and 18 others with violating Georgia's anti-racketeering law. Two other Trump lawyers pleading guilty just yesterday. And add to that report that former Trump White House Chief of Staff Mark Meadows has been granted immunity in the January 6th probe. That, of course, coming from ABC News. ABC is reporting that Meadows told Special Counsel Jack Smith that Trump was dishonest on election night. Our national political correspondent Avajoy Burnett tracking it all right now in Washington. Avajoy, this comes on the heels of one of former President Donald Trump's attorneys pleading guilty in the Georgia 2020 election interference case. Jenna Ellis taking that plea today. How significant is this deal, and are the dominoes starting to fall?
Yeah, well, let's start out with Jenna Ellis first. This is a significant update that has come in that Georgia election interference case. She's the fourth person to get a plea deal here. She's the third attorney to do so. And if you wanted to get an idea of just how significant Jenna Ellis is in the entirety of this RICO case, just take a look at...
Trump vowed martial law during the Fox appearance, suggesting he might use military force to stay in power if Congress tried to remove him. A statement so authoritarian and so threatening that it should have terrified every American regardless of their political affiliation. Representative Al Green, who had been pushing for Trump's impeachment for years, forced the floor action after the Caracas strikes provided what he argued was the final justification for removal. Green had been consistent in his belief that Trump was dangerous and should be removed from office, but even he seemed stunned by the speed with which events had unfolded. The unconstitutional war on Venezuela, combined with the documented war crimes from the boat strikes where survivors had been executed in the water, made immediate impeachment action a constitutional necessity in Green's assessment. He stood before his colleagues and argued that Congress had a duty to remove a president who had committed crimes against humanity, who had violated the Constitution, who had authorized extrajudicial killings without due process, and who now threatened martial law when faced with accountability. The motion to table objections to H.R. 353 passed with 23 Republicans breaking with their party on the procedural vote and 10 Republicans actively voting to advance the impeachment. This mirrored an earlier vote where Democrats had first shown they had the numbers to move forward, but now the situation was even more dire for Trump because the evidence was even more damning and the Republican defections were growing. Speaker Mike Johnson tried desperately to hold his caucus together, warning that impeachment would doom Republicans in the upcoming midterms. But 23 Republicans voted against his position anyway, a stunning repudiation of his leadership that showed how badly Trump had damaged the party. These Republicans understood that defending Trump after the war crimes leaks was political suicide in their districts, that their constituents would never forgive them for supporting a president who had authorized the massacre of civilians and the execution of survivors floating in the water. The full scope of what H.R. 353 actually contained was staggering in its breadth and seriousness. The original resolution had been introduced months earlier and contained 7 articles of impeachment covering obstruction of justice, abuse of power, contempt of Congress, and tyranny. But the resolution had been revived and supercharged on January 3rd with new evidence and a new article specifically addressing the Venezuela situation. Article 8 now charged Trump with unconstitutional war on Venezuela, based on the Caracas strikes that violated Article 1 of the Constitution and the War Powers Resolution, along with the leaked documents showing 115 extrajudicial killings in the boat strikes and the execution of survivors. The resolution now had over 210 co-sponsors, including 10 Republican flippers who had decided they could no longer defend Trump's conduct. The 7 original articles of impeachment covered the full range of Trump's misconduct during his second term. Article 1 covered obstruction of justice related to the Epstein files, cover-up where Attorney General Bondi had deleted files, and FBI Director Patel had fabricated classified seals to hide damaging information. Article 2 covered abuse of power related to Trump's interference with the fraud case and his attempts to avoid accountability for the massive judgment against him. Article 3 covered contempt of Congress for Trump's refusal to comply with subpoenas and oversight requests. Article 4 covered threats and intimidation against judges, prosecutors, and witnesses, including Trump's attacks on Judge Engoron and his calls to impeach the courts. Article 5 covered violations of the Emoluments Clause and corruption. Article 6 covered abuse of the pardon power. Article 7 covered general tyranny and undermining of democratic institutions. And now Article 8 covered the unconstitutional war on Venezuela. Together, these 8 articles presented a comprehensive case that Trump had violated his oath of office and must be removed. The evidence supporting Article 8 was overwhelming and included both the Caracas strikes and the boat strike massacres. The leaked OLC memo authorized lethal force against suspected boats without warrants, leading to 115 deaths across 35 strikes. The operational reports documented the execution of survivors floating in the water after their boats were destroyed. The September 2nd strike specifically showed 2 survivors being killed after they posed no threat. Judge Sullivan's ruling found that the Caracas strikes violated Article 1 and the War Powers Resolution because there was no imminent threat justifying executive war-making without congressional authorization. The UN report characterized the boat strikes as suspicion-based killings that constituted atrocities comparable to Maduro's torture. Governor Newsom's demand for ICC prosecution added political weight to the war crimes allegations. All of this evidence was now part of the congressional record supporting impeachment. The procedural vote of 237 to 140 to table objections meant that full floor debate on the impeachment articles could now proceed. This was not the final impeachment vote. that would come after debate when the full House voted on each article separately. But the tabling vote showed that Democrats had the numbers to impeach Trump on the floor. With 23 Republicans breaking on procedure and 10 actively supporting advancement, the final vote could potentially include significant Republican support for at least some of the articles. The war crimes evidence in particular was causing Republicans to reconsider their positions. It was one thing to defend Trump against charges of obstruction or abuse of power that could be characterized as political disputes. It was another thing entirely to defend a president who had authorized the execution of people floating helplessly in the water. The moral weight of the war crimes allegations was breaking through partisan loyalty in ways that previous impeachment efforts had not. Speaker Johnson's warning about midterm doom actually cut both ways and may have encouraged some Republicans to vote for impeachment. Johnson argued that impeaching Trump would hurt Republicans in the upcoming elections, but many Republicans in swing districts understood that defending Trump after the war crimes leaks would hurt them even more. They were making a calculated decision that being associated with impeachment was less politically damaging than being associated with a president who had committed atrocities. The 23 Republicans who broke with Johnson on procedure and the 10 who actively voted to advance impeachment were trying to create distance between themselves and Trump before the midterms. They wanted to be able to tell voters that they had stood up against Trump's worst excesses, even if they had supported him on other issues. Johnson's inability to make the midterm doom argument stick showed how badly Trump had damaged the party. The parallels to Trump's previous impeachments were striking, but this one was fundamentally different because of the war crimes evidence. Trump's first impeachment in 2019 was over the Ukraine phone call, where Trump pressured a foreign leader to investigate his political opponent. That was a serious abuse of power, but it was fundamentally a political dispute that Republicans could dismiss as partisan overreach. Trump's second impeachment in 2021 was over January 6th and the incitement of insurrection. That was an attack on democracy itself, but Republicans could argue that Trump's speech was protected and that he hadn't directly ordered violence. This third impeachment, Trump's fourth, if you counted the second-term impeachment effort that didn't reach a vote, was built on documented war crimes that could not be dismissed as political disagreement. 115 people were dead. Survivors had been executed in the water. The documents proved it. The UN had characterized it as atrocities. A federal judge had ruled the strikes unconstitutional. There was no political spin that made executing helpless survivors acceptable. The 10 Republican flippers who voted to advance impeachment represented a significant crack in Trump's support that could grow as the process continued. These weren't never Trump Republicans who had opposed him from the start. These were members who had generally supported Trump's agenda but could not defend war crimes. As floor debate proceeded and more evidence was presented, additional Republicans might conclude that they could not vote against impeachment without destroying their own political futures. The magic number for conviction in the Senate was 17 Republican votes, assuming all Democrats voted to convict. Getting 17 Republicans to vote for removal had seemed impossible before the Venezuela revelations. Now, with the war crimes evidence and Trump's martial law threats, 17 might actually be achievable. Republican senators were watching Trump's behavior and calculating their own political survival. Some of them represented states where Trump was deeply unpopular and where defending him could cost them their seats. Trump's threat of martial law during his Fox News appearance represented a dangerous escalation that was itself grounds for concern about his fitness for office. A president who threatened to use military force against Congress to prevent his constitutional removal was a president who posed a threat to democracy itself. The 25th Amendment existed precisely for situations where a president demonstrated inability or unwillingness to discharge his duties in accordance with the Constitution. Trump's martial law threat suggested he viewed himself as above constitutional constraints and would use force to maintain power if necessary. This rhetoric aligned with authoritarian leaders around the world who refused to accept democratic accountability. Trump was telling the American people that he would not go peacefully if Congress exercised its constitutional power to remove him. That statement alone justified immediate action to remove Trump before he could follow through on his threats. The market reaction to the impeachment vote had been volatile as investors tried to figure out what came next. The initial reaction was fear about political instability and the possibility of Trump following through on martial law threats. But some analysts were suggesting that Trump's removal might actually be positive for markets because it would end the chaos and uncertainty that Trump's erratic behavior had created. The Venezuela strikes had crashed markets 8% in a single day. Trump's meltdowns and flight from Washington had created additional uncertainty. The war crimes leaks had added to the chaos. If Trump was removed and replaced by a more stable leader, markets might actually rally on the hope of normalized governance. This created a perverse dynamic where Wall Street might actually welcome impeachment as a path to stability. The connection between the impeachment vote and all the other crises Trump was facing created an overwhelming convergence of pressure that no president could survive. Judge Sullivan had enjoined Trump's military operations. Governor Newsom had formed a blue state coalition defying federal authority. Over 120 lawmakers had already called for resignation before the impeachment vote. Trump's assets were being seized in New York. FBI Director Patel was facing arrest threats for the Epstein cover-up. Trump had been physically thrown out of a courtroom for contempt. And now the House had advanced impeachment with Republican support. Every institutional check on presidential power was activating simultaneously. Trump was facing pressure from the courts, the states, Congress, public opinion, and the markets all at the same time. There was no relief anywhere. There was no ally who could save him. Trump was isolated and surrounded by forces seeking his removal. The timeline from here moved quickly because the House could proceed to floor debate and a final impeachment vote within days. If the House voted to impeach, which the procedural vote strongly suggested they would, the articles would go to the Senate for trial. The Senate Majority Leader would set the trial schedule. The trial itself could take weeks as evidence was presented and witnesses were called. But given the urgency of the situation, Trump was threatening martial law and had already been enjoined from military operations. There might be pressure to conduct an expedited trial. The question was whether 17 Republican senators would vote to convict. That had seemed impossible after the war crimes leaks and Trump's martial law threats. It was at least conceivable. Some Republican senators had already expressed concern about Trump's behavior. If those concerns translated into conviction votes, Trump could actually be removed from office. The 14th Amendment implications added another dimension to the impeachment. Section 3 of the 14th Amendment barred anyone who had engaged in insurrection or rebellion from holding federal office. If Trump was convicted on articles related to his defiance of constitutional order, including his threats of martial law and his unauthorized war-making, he could potentially be barred from ever holding office again under the 14th Amendment. This would prevent Trump from running for president in any future election. Democrats were likely to argue that Trump's conduct constituted the kind of rebellion against constitutional authority that triggered the 14th Amendment bar. Even if Trump was not convicted in the Senate, the House impeachment itself created a record that could be used in future 14th Amendment proceedings. The bigger picture here was that we were watching constitutional democracy work the way it was supposed to work when a president went rogue. The courts had blocked Trump's unconstitutional military action. The states had formed coalitions to resist federal overreach. The House had advanced impeachment with bipartisan support. Every institution designed to check presidential power was doing its job. This was the system the founders had designed being stress-tested by the most dangerous president in American history. And so far, the system was holding. Trump was being constrained and potentially removed through constitutional processes rather than through violence or chaos. Trump's threat of martial law showed that he understood the walls were closing in and that he might not be able to escape through normal political means. A president who was confident in his position wouldn't threaten military force against Congress. Trump was threatening martial law because he knew he was losing and because he was unwilling to accept democratic accountability. The war crimes evidence that had triggered this impeachment would follow Trump regardless of the outcome. Even if the Senate failed to convict, Even if Trump somehow survived this crisis and served out his term, he would be remembered as a president who had authorized the massacre of 115 civilians and the execution of survivors in the water. The leaked documents were now part of history. The UN characterization of atrocities was on the record. Judge Sullivan's ruling was published. No amount of screaming about fake news could make this evidence disappear. Trump's legacy was sealed as a war criminal, regardless of what happened with impeachment. The next few days and weeks were going to be the most consequential period in American political history since Watergate, or possibly since the Civil War. A president was facing impeachment for war crimes while threatening martial law to stay in power. The House had advanced articles with bipartisan support. The Senate might actually have the votes to convict if Republican defections continued. And Trump was hiding at Mar-a-Lago having meltdowns and making threats instead of governing. This was what the collapse of a criminal presidency looked like in real time. What came next was a series of rapid procedural steps. The House would proceed to floor debate and a final impeachment vote. The evidence would be presented publicly. More documents might leak. More Republicans might flip as the pressure intensified. The Senate would receive the articles and conduct a trial. 17 Republican senators would have to decide whether to remove a president who had committed war crimes and threatened martial law. And Trump would continue raging from Mar-a-Lago, growing more desperate and more dangerous as his options narrowed. The constitutional crisis was reaching its climax, and the outcome would determine whether constitutional government survived or whether a president could commit war crimes and threaten martial law without consequences. The House had spoken. Now everyone was waiting to see if the Senate had the courage to finish the job.